Hello, I'm Sister Tandy. When a workplace incident occurs, the moments immediately after it matter enormously. Not for assigning blame, but for protecting the injured person, fulfilling legal obligations, and gathering the information needed to prevent the same incident from happening again. Today, we are covering two interconnected obligations: incident reporting under the OHS Act and the COID claims process that protects your workers when they are injured at work. We are also looking at how incident investigation connects to prevention. This is not about fault, it is about learning. Let's begin. Under Section 24 of the OHS Act, employers must report certain incidents to the Department of Labor. Reportable incidents include any incident that results in the death of a person, any incident that results in unconsciousness, amputation, dislocation of a major joint, fracture of a bone, laceration requiring suturing, loss of sight, or any injury requiring medical treatment more than first aid. Also reportable, the disappearance of any person from a workplace in circumstances that could suggest death or injury. And under COID, any work-related injury that causes a worker to be absent from work for 3 or more days, regardless of whether medical treatment was required. Additionally, certain occupational diseases listed in Schedule 3 of COID must be reported when diagnosed. If you are uncertain whether an incident is reportable, report it. The consequences of underreporting significantly outweigh the administrative effort of an unnecessary report. Reportable incidents must be reported to the Department of Employment and Labor within the prescribed timeframes. Fatalities and serious injuries, those meeting the Section 24 criteria, must be reported as soon as possible and in any event within 7 days. The prescribed form is Annexure 1 to the OHS Act regulations, available from the Department of Labor's website and from your industry association. For COID claims, the employer must report using the W.CL.2 form, the employer's report of accident, within 7 days of receiving notice of an injury. For occupational diseases, the W.CL.1 form is completed by the treating health practitioner. All reports should be submitted to the Regional Compensation Commissioner's office. Underreporting or late reporting can result in the compensation fund holding the employer directly liable for any compensation paid, rather than absorbing it as an insured event. COID, the Compensation for Occupational Injuries and Diseases Act, provides a no-fault compensation system for workers who are injured or contract a disease in the course of their employment. A worker who qualifies for COID does not need to prove that the employer was negligent. They need to establish that the injury or disease arose from their work. Benefits include medical costs. The compensation fund covers the cost of treatment for the workplace injury or disease. Temporary disablement. If the worker is unable to work for more than 3 days, they receive a weekly payment equivalent to 75% of their earnings for the duration of the temporary incapacity. Permanent disablement. If the injury results in lasting impairment, a lump sum or monthly pension is payable. Death benefits. If a worker dies from a workplace injury or disease, their dependents receive a lump sum and a monthly pension. To benefit from COID protection, employers must fulfill 3 ongoing obligations. First, registration with the compensation fund. Every employer who employs workers, including domestic employers, must be registered with the fund. Registration is completed through the Department of Employment and Labor. Second, annual return of earnings. Every year, employers must submit a return of earnings, their total payroll for the preceding year, by 31st of March. This determines the annual assessment fee payable. Third, timely incident reporting. As covered, every qualifying incident must be reported within 7 days. An employer who fails any of these obligations loses the protection of the fund for incidents that occur during the period of non-compliance. They become directly liable for any compensation payable to the worker. COID compliance is not optional. It is the foundation of your workers' protection and yours. An incident investigation is one of the most valuable safety tools available to any organization if it is done correctly. The purpose of the investigation is not to find someone to blame. It is to understand what happened and why, so that it cannot happen again. Every investigation should answer 5 questions. What happened? A factual chronological account. Who was involved? Not for blame, but for witness accounts. What were the conditions? Environmental factors, equipment state, procedural adherence. Why did it happen? The root cause, which is almost always a systemic issue, not an individual failure. What must change? Specific, assigned, time-bound corrective actions. The root cause of most workplace incidents is not an individual who made a mistake. It is a system that failed to prevent that mistake. Investigation that surfaces the system failure prevents the next incident. A worker recovering from a workplace injury has a legal right to a safe return to work, and a structured return to work plan serves both the worker and the employer. Under COVID, a worker who has received temporary disablement benefits returns to work when declared medically fit by a healthcare practitioner. But fit for duty does not always mean fit for all duties. A phased return, starting with lighter duties, shorter hours, or a different role while full capacity is restored, reduces re-injury risk, supports the worker's confidence and recovery, and demonstrates the employer's genuine care. A return-to-work certificate issued by an occupational health practitioner should specify what the worker can do, what they cannot do, for how long these restrictions apply, and what follow-up assessment is required. CareNet Consultants practitioners issue clear, specific fitness for duty assessments that support smooth, safe workforce reintegration. A complete incident management system has 4 components that work in sequence: prevention, risk assessments, medical surveillance, training, and hazard control systems that reduce the likelihood of incidents. Response, an emergency response plan that specifies what to do in the first minutes after an incident: who to call, how to provide first aid, how to secure the scene, how to notify emergency services. Reporting, a clear procedure for completing and submitting OHS Act and COID documentation within the 7-day window. Learning, an investigation process that surfaces root causes and assigns corrective actions with owners and deadlines tracked to completion. Most organizations have elements of this system. Few have all 4 integrated and consistently applied. When all 4 work together, incidents decrease, liability decreases, and the culture shifts from reactive to preventive. Workers who are injured at work have specific rights that must be respected. You have the right to receive first aid immediately. Your employer must maintain a first aid kit and trained first aiders on site. You have the right to receive medical treatment for your injury at the employer's expense under COID. You have the right to report the incident without fear of intimidation or retaliation. Victimizing a worker for reporting an incident is a criminal offense under the OHS Act. You have the right to COID benefits without waiving your right to civil action in cases of gross negligence. You have the right to be accompanied by a representative during any incident investigation interview. And you have the right to a copy of the incident investigation report. These rights exist to ensure that the incident reporting system serves everyone, not just the employer. Before you go, here is something for every finance-minded leader in this audience. Research by the HSE in the UK, whose findings are consistently mirrored in South African contexts, found that for every R1 paid in insured costs for a workplace incident, 5 to 10 Rand is spent in uninsured costs. Lost time, investigation, reduced productivity, temporary replacement, and reputational damage. Prevention is always cheaper than response. From all of us at CareNet Consultants, your best is good enough for today. See you in the next video. CareNet Consultants, your partner in workplace health.